Hi, this is Lori, and you are listening to and watching this recording because classes have been canceled for Thursday, January 31st due to the extremely freezing temperatures that we are experiencing. So I am certainly hopeful that everyone is staying safe and warm during this time. But the chapter that we are scheduled to discuss or look at on Thursday is Constitutional Law, Chapter 5. And I've already mentioned some of the constitutional provisions and was hopeful that in class we would look at the Constitution together, but we won't. So I'll highlight some parts of my PowerPoint that will help you understand the role of the Constitution and how it creates the power of our government and lays the foundation for all of the laws that exist in our country. So you may be familiar with the U.S. Constitution is the real first major formalized document that established the laws in our country. And the preamble very often is cited as a reference, "We the people of the United States to form a more perfect union," and so forth. Just sets the basis for what's going to come forward, or what's going to follow the preamble in the Constitution. So at every point with every law, whether it's case law, executive orders, statutes, they must be in compliance with the Constitution. The Constitution is the supreme law of our land. The supreme law of our land means that no law should violate the Constitution. And that means that lots of laws can be challenged or are challenged on the basis of whether or not they are constitutional. While most of this discussion will focus on the federal Constitution, that's what the U.S. government is, a federal government, each state also has its own individual constitution. So Illinois has an Illinois Constitution, and it is very similar to the U.S. Constitution. But the focus of Chapter 5 really is the federal Constitution. The Constitution sits above everything else. No law can conflict with it. And that's what I was just saying, that it is the foundation. It is the supreme law of the land. And so, for example, if the Constitution grants individuals the right to freedom of speech, which means that we can't have a law in our society that takes away that right. I mean, I will discuss momentarily how the government can have some restriction, but the government can't take it away. The directive of the Constitution, or I should say the Constitution in its first 3 articles, establishes the branches of government, and then it establishes the power of the states, and then we have the Bill of Rights, which is focusing on the individual rights of the citizens, and then the amendments that follow, which are still primarily focusing on individual rights. So some focus on, for example, the term of the presidency, and so forth. So separation of powers. The first 3 articles of the Constitution establishes the government, the legislative branch, the executive branch, and the judicial branch. Those are 3 branches of government. And each one of those 3 branches are created independently, and they act as a check on the power of the other 2. Each branch has its own power, and one branch does not have any more power than the other. So the office of the presidency is not more powerful than the legislative branch, and neither one of those is more powerful than the judicial branch. They are considered to be equal powers that has the ability to check the other branch. Oops, I didn't mean to do that. And what that means is, sorry about that. What that means, for example, is when the U.S. Congress enacts a law or passes a bill and then sends it to the president to sign it, the president can veto it, and then Congress can go back and rewrite it. And they have powers to override his veto. That's one way of checking the president. You are currently seeing in current time Congress check the current president. The current president would like additional funding for a wall at our borders, but Congress is saying no. That's a check. That's a check in the balance of powers. One branch wants to do something, the other branch says no. One branch wants to pass a law, the other branch, thus being the executive branch, says no. The executive branch has the power to carry out the law. The legislative branch has the power to enact the law. So what about the courts? What are they there for? The courts are there to interpret and apply the law, to determine perhaps if a law is unconstitutional. So for example, if Congress, and Congress has passed many laws on gun control, and Article 1, Section 8 of the U.S. Constitution does not explicitly give Congress the power to regulate guns, but they've taken control of that through the Interstate Commerce Clause. And in doing so, someone can challenge that Congress has exceeded their power, that what they have done is unconstitutional. And that challenge would rise through the courts and eventually perhaps reach the U.S. Supreme Court, to the extent that the U.S. Supreme Court could say, you're right, Congress has exceeded its power and the law that has been enacted is unconstitutional. So just because something becomes a law does not have to mean that it meets the constitutionality test. There are challenges all the time to whether or not a law is constitutional, or whether or not an act of the president is constitutional. I should say an executive order of the president is constitutional. Some of you may recall that after President Trump was inaugurated, one of the first executive orders that he signed was to put a ban on people from certain countries coming into our country. And it amounted to a religious ban. So the executive order was challenged on the grounds that it violated separation of church and state, and that the president was attempting to regulate, in some ways, religion. And that issue reached the U.S. Supreme Court, where the U.S. Supreme Court decided at that time that the argument that the president was seeking to ban certain religions was unconstitutional, meaning he didn't have the power to do that because it breached or violated the terms of the Constitution. Another example of challenges in the law that arise to the U.S. Supreme Court would be when President Obama and Congress at that time enacted the Affordable Care Act, which is commonly known as Obamacare. And there were challenges to whether or not that was constitutional. And it reached the U.S. Supreme Court, and at that time the U.S. Supreme Court determined that the sections of the Affordable Care Act was in fact constitutional. So that's what the court does. The court is another check on our laws to determine if our laws are constitutional, though the U.S. Supreme Court has the power to decide cases that arise under federal law as well as the U.S. Constitution. But the main takeaway from this is 3 branches of government. They are equal powers, and they serve to check the others, so that our country does not have any one person or entity obtaining complete control of our country. But that is about the structure of the government. Who's going to make the law? Who's going to carry out the law? Who's going to determine what it means? What about you and I? What about the individual citizens? What rights do we have? And that is from the Bill of Rights, which are the first 10 amendments to the U.S. Constitution. The Bill of Rights are strong protections for the citizens against its very own government. See, the freedom of speech is about actually giving citizens the power to protest its own government. Because think about this. What if we didn't have that power? What if really that anyone who speaks out against the government could be sentenced to incarceration? The government says, oh, we don't like that, so we just lock you up. So the framers put as one of the provisions in the Bill of Rights that citizens would have the right to protest. The citizens would have that freedom of speech, that the government can't regulate what you say. And again, I'm going to get to in a moment how they can regulate to some extent freedom of speech. But another strong protection that we hear a lot about is separation of church and state, that the government should not be enforcing or supporting any particular religion, that everyone is entitled to engage in the religion or not to engage in a religion, that our country should not adopt any faith. Now, some people believe that our country was founded on Christian principles, which is actually a myth. Many of the framers were not Christians. Thomas Jefferson himself was not necessarily a Christian, but he believed in protecting the rights of people who wanted to be Christians as well as people who did not. So our country really wasn't founded necessarily on Christian principles to the extent that we should be abiding by the King James Version of the Bible. The framers were really adamant about protecting. I mean, that's in part why they came here for religious freedom. So they didn't come here for religious freedom only to then restrict and refine those freedoms. So freedom of religion. The government should keep its hands out of religion in two ways. Should not tell people what they should or whether or not we should be faith-based individuals. So there's free exercise of religion, and that the government shall not support any particular religion. I mentioned in class that there's strong protections in the Bill of Rights for the accused, the defendant in a criminal case. The right to a jury trial belongs to the accused in a criminal case, not to the prosecution in the criminal case. A right to a speedy trial, a right to a lawyer, a right to remain silent. The Fourth Amendment protects us against unreasonable search and seizure from the government. Those are strong protections, and I don't think want them taken away, because then we empower our government even more to easily take people's property or incarcerate them or decide whether or not we should have a faith, and should our schools be religious schools, and how should we further conduct our day-to-day lives. So that's something to think about with the Bill of Rights. Of course, there's lots of strong arguments about the Second Amendment, which is the right to bear arms, and what was the spirit of, or the intention of, the framers on the Second Amendment right to bear arms. And that's going to remain controversial. The language of the Constitution itself is not clear. And it will ultimately be up to the U.S. Supreme Court to tell us what they think that language means. So at any point, the structure of that court could reframe what the language means. They can't reframe the actual language, but they can tell us what they think the language means. So that means any one person could change an outcome on that court. The Interstate Commerce Clause, and specifically Article 1, Section 8 of the U.S. Constitution, is when we think about how laws are enacted, not what are the terms of Congress and how are they elected. Article 1, Section 8 specifically is about the power of Congress. What can they do? See, Congress doesn't have unlimited power. They just can't pass laws on whatever they want to pass laws on. They're actually restricted, and if you look at Article 1, Section 8, you will see what they are given the power to do. And if it's not listed there, they don't have the power to do it. But there are two clauses specifically that gives Congress lots of power above what is explicitly given. And that's the Interstate Commerce Clause. I mentioned this in class before. The Interstate Commerce Clause allows Congress to regulate economic activity. So think about that. Economic activity. That's almost everything. So it's through the Commerce Clause that Congress could have the power to regulate guns, regulate food, regulate transportation through the Interstate Commerce Clause. There's another clause called the Necessary and Proper Clause. The Necessary and Proper Clause at the end of Article 1, Section 8 just really means that whatever Congress has to do to carry out its other powers, they can do so. It doesn't mean that Congress can do whatever Congress thinks is necessary and proper. It's necessary and proper to carry out the other components of Section 8. So the main takeaway from Article 1, Section 8 is that Congress does have limited powers. Within those limited powers, there will be some broad powers extended, but they do have limited powers. I've already mentioned the Supremacy Clause. The Supremacy Clause makes the Constitution, the federal statutes, the treaties, and the supreme law of the land. I've mentioned the First Amendment. Congress shall make no law abridging the speech, and speech also includes symbolic conduct. Political speech is protected unless it's intended and likely to create imminent lawless action. However, Congress can regulate time, place, and manner. So Congress can't regulate content. Freedom of speech gives people freedom to the content. What Congress can regulate is when that content is exercised, where it's exercised, and what manner, which is still very limited in how freedom of speech can be protected. And on my slide, I have, what about Ice-T's Cop Killer? And I have that here because it brings us back to, for people who think that, yes, that is extremely offensive language, why would we allow people to sing about killing police officers? And that's because Congress can't regulate that content. In fact, some of that content goes directly to the speech that was intended to be protected. See, police officers are an extension, they're part of our government. And freedom of speech is there to allow people to express their dissent, dissatisfaction with the actual government. So there's many arguments to say that Ice-T's rap or music is in fact what freedom of speech is, one of the examples of what freedom of speech is intended to protect. The U.S. Supreme Court has decided that certain obscene language is not protected. And they actually said in their opinion that you'll know it when you see it. Child pornography, for example, is not protected under freedom of speech. And there's a three-part test to obscenity, and that's what you're seeing on the slide. So the takeaway from this, the government can regulate time, meaning can we go protest in front of the White House at 3 a.m. in the morning? Probably not. They will tell us we need to get a permit to maybe come at 7 a.m. or 6 a.m. in the morning. Place, can we just show up anywhere and protest? Probably not. The government can say these are places that your protests can happen. And the manner of speech. Can we throw items at the White House? No. Can we walk in front of the White House? Yes. So the government can regulate time, place, and manner, and a lot of that goes to safety, but cannot regulate content. Oops. So bear with me. All right. So the other section of the U.S. Constitution, another amendment that you want to be familiar with this chapter is equal protection. The 14th Amendment provides, generally requires the government to treat people equally. And that's where we hear much discussion about diversity, affirmative action, equal opportunities, and what is equal. And does equal mean fairness? And does that mean equity? So all of us, including corporations or businesses, are afforded equal protection under the Constitution. What that really means is that people who are similarly situated should be treated the same. Your textbook does talk about some tests to determine whether or not an act or law of the government or policy is in fact violating the 14th Amendment. The 14th Amendment is a directive to your government in terms of how, again, it is supposed to treat its citizens. So I want to look at a couple of examples. In your textbook, if you look at page 122, there's a case decided by the U.S. Supreme Court in 1989, Texas versus Johnson. Texas versus Johnson is one of the significant cases about flag burning. Now, some people really honor the flag that's a symbol of our country, and they feel like no one should be able to burn it. But Mr. Johnson did burn the flag, and the case reached the U.S. Supreme Court on the issue really is that does the First Amendment protect flag burning? And the answer to that is yes, meaning people have a right to burn the flag. In the decision by the U.S. Supreme Court, they focused on burning the flag, again, is likely one of the protections that the First Amendment was intended to protect, that people could show protest, dissent, and dissatisfaction with this government, because that is how you get a better government, when people are able to say, hey, you're not working the way we think you should for everyone's interest. Let's see, can we improve our government? Without being able to complain, protest, dissent, show dissatisfaction, then the people in power get to do whatever they want to. Think about that too with freedom of speech and those who have speech that are very adverse to maybe your own interest. So the Texas versus Johnson case is about, or the spirit, I should say the spirit, the ruling is flag burning is constitutional. It is protected by freedom of speech. I was hopeful that if we were in class, we could discuss how is that very similar to Kaepernick taking the knee and other players taking the knee at the national anthem. There's been much controversy about whether or not in a football game or prior to the game beginning, should players have to honor the national anthem? Can they take their knee as a measure of protest? Kaepernick was doing that as a measure of protest, not as a dishonor necessarily, same way the flag burning may not have been a dishonor to the country, but to say, I am protesting what my country is doing. And for those of you who are familiar with the dispute, you know that some people think that it's an outrage that anyone would not honor the national anthem. Some people probably even know what it is and why we have it and what the words are, but that's setting all that aside and coming back to that arguably taking the knee for the national anthem is very similar to flag burning. It is a way of protesting. Now, another issue with Kaepernick is whether or not those protests should occur in a setting like a football game. But what's interesting is that in the past, the U.S. Supreme Court has declared the NFL as quasi-public, which means if they're quasi-public, then this applies to them very strongly that the players would be able to, before the start of the game, because that's when the anthem is acknowledged, be able to take the knee in protest, that they cannot be forced to honor the anthem. And that's the other way to look at what's the options here. If you can't protest, do you then have to honor the national anthem? So I was hoping that in class we could have some discussion on the similarities and differences of flag burning and people protesting by not honoring the anthem or saying the Pledge of Allegiance and so forth. The 14th Amendment, I mentioned I wanted to talk about some examples: equality, equity, and fairness. So when you think about equal opportunity in our society, equal opportunity doesn't mean that everybody is treated the same. You might think equal, like 2 + 2 = 4, means the same. But under equal protection of the law, it doesn't mean that everyone is treated the same. And this becomes clear when you think about, sorry, I pressed my button again. Okay, this becomes clear when you think about people with disabilities. So if someone is disabled, or I should say have to be in a wheelchair, but need to access a building, buildings now have to comply with the American Disabilities Act and allow handicap accessible entrances. But now you may have noticed, or not, at College of Lake County, there are some entrances that are handicap accessible, but all of them are not. So think about this. Anyone who is not in a wheelchair can go through any entrance to College of Lake County. But those who are in a wheelchair can only get into the inside the college through certain entrances. They are giving equal opportunity, they are giving equal access, but they are not treated the same. So equal opportunity doesn't mean that we are treated the same. It means that people are given equal access or equal opportunity to those or equal access to those opportunities. And that's where the fairness of equal protection arises, that you create a system that allows fairness of opportunities, and that we are looking at in our society, we all have similarities and differences that may impact how we access opportunities. So the goal of the equal protection is to allow our government to create a system that allows equal access. But remember, equal access does not mean that everyone will be treated the same. And in doing so, doesn't mean that that is unfair. The fairness is that your government is creating a pathway to equal opportunities. That also establishes equity. Equity means that then we are treating our society the same way, that we're giving all the members of our society the protection that's due under the laws of our society. That's how you build an equitable system. However, if we don't have that, and some people, let's go back to disabilities, if we don't have that kind of equity and equality in our system, then arguably people with disabilities wouldn't be able to access buildings. That's why we have the law. You may think that's always been the case. It was not. It was not always the case that especially public facilities, and now most businesses have to comply, that companies and even public places provided access. They did not. And we could take this discussion into talking about education and employment and housing. How do we create equity systems that everyone has access to protection under the law? All right, that was just a question we would have talked about in class. By creating 3 independent and equal branches of the federal government, the U.S. Constitution prevented the federal government's power from being concentrated in one person. And that would be true. All right, that brings me to the end of this discussion of kind of highlights. There are some quiz questions. I encourage you to look at the terms, I should say the material under the exam view as you're looking at Chapter 5. If you have any questions or comments, please contact me. Otherwise, I look forward to seeing everyone next Tuesday in class. Have a great rest of the week.